Welcome to the Bar of Ireland podcasts. In this episode, I'm joined by Cathy Smith, Senior Counsel and Chair of the ADR Committee at the Bar of Ireland.
When we look to what we're trying to achieve in a mediation, we're trying to get to that point of an agreement that is enforceable and binding and that gives finality.
And Aoife Farrelly, a practising barrister at the Bar of Ireland.
Now the Injuries Board deals with psychological claims and they're much more complex than physical claims, physical injuries.
Cathy and Aoife recently co-authored an article for the October Bar Review in which they analysed the provisions of the Personal Injuries Resolution Board Act and how it will impact on the mediation of personal injury disputes. Cathy, Aoife, thank you very much for joining me. And Cathy, I might start with yourself. Just to give a bit of context to the topic, I wonder if you could outline what the current typical process is for mediations of personal injury disputes.
Thank you, Andrew. I suppose mediation can happen at different stages in disputes. You can have pre-litigation mediation, but in truth, it's quite unusual in the context of personal injuries, and there's a good reason for that. And in fact, mediation is usually considered by the parties at a very advanced stage and shortly before the matter will be ready to go to trial. And the reason for that is it is usually only at that point that the issues have fully crystallised, that parties know what the issues are in relation to perhaps negligence, expert evidence has been procured, and of course, particularly, what is the situation in relation to the injury suffered by a plaintiff. And again, all of the medical evidence at that stage will have been available. And of course, there may have been a lengthy discovery process, again, including medical records and so on. So in truth, it is usually at an advanced stage and effectively to avoid the case having to go to hearing, that mediation is usually considered at that stage.
And the article mentions a bit about how COVID has sort of changed the landscape a little bit in respect to this. And I wonder, Aoife, if you could maybe tell me a little bit about that.
Well, I suppose before COVID, personal injuries probably didn't really enter the mediation arena to the same extent as maybe other branches of law. But with COVID and the closing of courts and the move to online platforms, unfortunately for personal injuries lawyers, witness evidence is a crucial part of personal injuries law, and that wasn't really appropriate for cross-examination through a screen. There wasn't the same engagement, I suppose, and unlike criminal law, which has the same issue, where witness evidence is a fundamental part, an integral part of the litigation process, where personal liberty was at issue, in criminal law, that same factor wasn't present for personal injury. So it was actually the last area of law to come back to full tilt, pre-COVID practice, I suppose, if you like. So personal injuries lawyers had to be, I suppose, inventive in how they were going to deal with their cases, which were now backing up, and the work that wasn't getting on. And so mediation became the only forum then that was available to personal injuries lawyers and to the area of personal injury for quite some time. And then that practice just continued on after COVID and actually transformed the area of practice for personal injuries law.
The article touches on the establishment of PIAB, the Personal Injuries Assessment Board. And what was the main reason for this being established?
Right. Well, that dates back to 2003, and it is the statutory body that independently assesses personal injury compensation payments. It was part of the government's approach, or I suppose their insurance reform programme. We all know that back at that time, insurance premium were very high, and at points beyond that remained very high. But in any case, back in 2003, there was a lot of public pressure to do something about high insurance claims and high insurance premiums. So that became part of the government's plan to deal with that. In 2003, the Injuries Board was set up, dealing only with cases where liability was not an issue. And because only a court could determine questions of liability, because they're, I suppose, essentially legal questions. But the focus on the Personal Injuries Assessment Board back then and throughout their tenure really has been on swift resolution and swift payments. And I think to a large degree that has been successful for a lot of plaintiffs.
One other thing that's touched on in the article, and I suppose it also gives a little bit of context just around the area in general, is the golden rules of mediation. And I was just wondering, for the uninitiated, could you tell us what some of those are?
Okay, so thank you, Andrew. So they're called golden rules, but some of them are stringent and some of them not so stringent, but they go to the core of what mediation is about. So the first one really is confidentiality. The entire process is confidential. Whatever a party says to a mediator is confidential unless that party gives the mediator permission to share that with the other side. The parties can agree that the fact that they went to mediation itself is not confidential, but anything said, any document prepared and so on in the mediation remains confidential. And that, I think, is really important because it creates a freedom for people to explore resolution in a way that they would not otherwise perhaps be able to do. And coupled with that is the fact that anything said in mediation, any potential concession from either side, is entirely without prejudice to their position in the litigation or in the larger dispute, up until the point that perhaps they reach a mediated agreement and they effectively settle their dispute. And again, that goes to the freedom to be creative when it comes to looking for solutions to what's in dispute between the parties. I think what's really at the core also is that mediation is voluntary. And so with that, it means that straight away, both parties are there because they want to be there. And there's a bona fides that comes out of that naturally, that they are both there to try and reach a resolution. And that's something that's a really good starting point to be at on the day of a mediation. There's a commitment that both parties are there of their own volition. And that also flows into how the mediation should run. In other words, it's the parties' mediation. And I know Aoife was talking earlier about how mediation was adopted perhaps in light of the situation during COVID by lawyers and embraced in a way that perhaps had not been done before. But the mediation is about the parties. And I think it's fantastic that lawyers are embracing it. But it's to facilitate the parties in moving forward, and the parties lead the mediation, facilitated by the mediator, guided and advised by their lawyers at the mediation. It's meant to be facilitative and non-adversarial, so complete opposite to what they would expect in court. And that's very important for the types of disputes that go to mediation, where generally relationships are at stake, whether it's an employment relationship or some other, perhaps a personal relationship in the context of family mediation and so on. So the fact that it's non-adversarial means that it doesn't do any more damage to the relationship than the issues in dispute have already done. And I think finality is very important. If the parties reach an agreement in a mediation and they sign up to that agreement, and it's an enforceable agreement, and we can talk about that afterwards, but it's the end of it. Whereas you can have a great outcome in court, but an appeal is still a prospect that may have to be faced by either party, or perhaps a number of appeals. So that's a really, really important part about mediation. And I think it's something that the parties really value when they come to mediation.
And I suppose just on that finality, generally, how are these decisions enforced? And does the increased use of mediation for personal injuries during COVID impact on this enforcement, or is it more difficult to enforce because of that?
Well, the enforcement comes down to the fact that an agreement is reached. So there's nothing enforceable about a mediation unless and until the parties reach an agreement. The mediator certainly can't enforce anything, and nothing said in a mediation, or as I said, any concessions or so on. None of that is enforceable. But the whole point of mediation is that the parties will reach an agreement, and that agreement will be reduced to writing and will be signed and witnessed, and all the formalities that are required for any contract would be followed. And then you have, hopefully, an enforceable contract, just like any other contract that people would enter into. And so the method of enforcement is to rely on the contract in court. And I suppose I don't know that I certainly don't think it's very common that mediated agreements become subject of such litigation themselves in the future. But the very fact that they could do, and the parties, especially if they're properly legally advised, they bear that in mind. They know that this is an enforceable agreement and it's to be abided by. I think one other point about enforcement comes from the Mediation Act, and that's the point about the confidentiality. So the agreement might be complied with in part, but what if somebody breaches the confidentiality of a mediation? And what happens then? And the Mediation Act provides that you can't rely on something that was said in a mediation or a document and so on that was produced in a mediation in court. Court will not permit it. So that's where the remedy lies. You go back to the statute there and you can rely on that if a party seeks to breach that aspect of it in for future litigation. So the remedies are both in statute and in the contract.
Typically, why would one choose mediation for a personal injuries dispute over litigation? What would the other reasons be, maybe from both the defendants and plaintiff's perspective?
Yeah, well, I suppose a lot of it goes back to the golden rules that Cathy has just spoken about, and they are the advantages that mediation will have over litigation. So, for example, confidentiality, that's an aspect for both parties that's beneficial to both parties. Without prejudice, the fact that the process is without prejudice, the fact that it's voluntary, that it's non-adversarial. So I suppose when I'll speak about it maybe initially from the plaintiff's point of view, and then maybe Cathy can deal with some of the defendant's aspects. But as a plaintiff, many times dealing with personal injury cases, one of the main issues for a lawyer dealing with their plaintiff is to try and keep them calm going into this adversarial process where they're going to sit down, swear on the Bible, be cross-examined, their full medical history be revealed to the whole court in open court, in public, and every aspect of the case along the way be tested and be rigorously investigated. And that's very daunting for people. So the idea that you can resolve your case without having to go through that is hugely, hugely beneficial for people. And likewise, I suppose, even for defendants who are maybe employees in various institutions, they too are exposed to that cross-examination. So it's beneficial to both sides from that point of view. Another aspect that occurs to me is we've all seen the headlines in national newspapers and then are translated onto social media platforms where teacher loses €60,000 case in circuit court. And while as lawyers we understand that that's not really a proper interrogation of the legal issues, and there are various reasons why a case might have been thrown out or dismissed, that's very worrying and very concerning for normal, ordinary individuals who just take a case because they feel they're entitled to take a case for whatever reason. And there might be various reasons why a case is dismissed, but an awful lot of the time that's not translated, particularly when it gets to social media. So you avoid all of that because it's confidential and it's non-adversarial in that way. So I think there's some of the benefits for plaintiffs. Certainly a lot of that translates to defendants.
I just wanted to add to that, and it's the question of cost. We hear a lot about legal costs all the time, but the reality is that while mediation does require an investment, it definitely can be a more cost-effective way of reaching resolution from a defendant perspective than lengthy litigation. Trials can be very expensive. They run for a long time. Large number of witnesses who have to be present, who are expert witnesses. That's all very expensive. And of course, then, as we mentioned earlier, the prospect of appeals later on. Against that, the investment in a day of mediation, in my view, mediation works when it is properly invested in. Now, it is quite common that defendants will bear the costs of the day of the mediation, the mediator, and perhaps the room, the facilities, and so on. So as I said, that is an initial investment from a defendant perspective. The other investment that can be very worthwhile is an investment in the lawyers who are representing the parties. Yes, of course, a person can engage in a mediation in an unrepresented capacity, And that, of course, follows the point I made that the mediation is about the parties. It's not about the lawyers. But when we look to what we're trying to achieve in a mediation, we're trying to get to that point of an agreement, a resolution that is enforceable and binding on both sides, and that gives finality. And that is greatly enhanced, in my view, when both parties have the benefit of legal advice at the appropriate parts of the mediation day. It may not be at the start, where in my view it's usually very much party driven, but to be able to advise a plaintiff about the likely quantum in terms of what the damage is if they were successful in court, that's something uniquely available to particularly I think a barrister who's practicing regularly in personal injuries, who has that insight and has that knowledge. And of course, solicitors, again, who practice in that area, have that knowledge also. And then there's often a point when in a mediation, and of course, a mediated agreement is a compromise, so nobody's getting everything they want. And that can be a very difficult part in a mediation, and it can be a difficult piece to get over the line. And that's where I think the role of legal representation is invaluable, because lawyers can assist the parties in understanding what the alternative looks like if the resolution that's available on the day is not something that they're, very keen on at that point. So that's the role. And then at the end, the point about having an enforceable agreement from a defendant's perspective, a party who enters into an agreement, a plaintiff who enters into an agreement in a mediation, who doesn't have the benefit of legal advice, is much better placed to seek to set aside that agreement later on the basis that they didn't understand the implications of what they were signing up to on the day. They didn't understand the impact in terms of their injuries or their future loss of earnings and so on. And in those circumstances, they may well be in a position to have their agreement set aside. And while mediators themselves may be lawyers, their role is not to give legal advice. And so for an unrepresented party, particularly in personal injuries mediations, I think that the prospect of ending up with a concluded, enforceable mediation agreement is greatly reduced if legal representation isn't part of the investment on the day.
Can I just pick up on a point Cathy made there about plaintiffs that are unrepresented? I think that's a very important point for defendants to consider when they agree to enter mediation. So if you're a defendant and you're coming up against a plaintiff that isn't legally represented, you need to make sure that it's explained to them in advance, whether by the mediator or by yourself, that they should be legally represented, or that it would be more beneficial to them if they were, and the consequences of the mediated agreement, and the enforceability of it once it becomes an agreement. Because as Cathy says, it is easier to resile from an agreement where you haven't been legally represented, but if you've waived your right to legal representation, that's a much more difficult position. So that's a factor definitely for defendants when they're dealing with these kind of cases.
I might just come back to the Personal Injuries Resolution Board Act. And I suppose there were a couple of concerns with the Act that were outlined in the article. I was just wondering what these concerns were, and also what type of mediation does the Act provide for, and does it differ from other forms of mediation?
I suppose the Act now and the Injuries Board itself has been expanded, the types of cases. So heretofore it was motor claims, employer liability claims and public liability claims. In 2022, the Garda Compensation Act was expanded to send those particular cases to the Injuries Board now as well. So they were cases that were traditionally liability wasn't an issue in those cases. These are cases where guards are injured in the course of their duties. So where malice isn't admitted, where malice is admitted, that those cases now go to the Injuries Board. But in addition to that, now the Injuries Board deals with psychological claims, and they're much more complex than traditional than physical claims, physical injuries. It's not as easy to foresee the length of a psychological injury for an individual in the same way as it is for a broken leg, if you like. So sometimes in those particular cases, the need for discovery is much more pressing, because somebody that has a history of psychological issues, that might impact on the value of the claim and the longevity of the claim. So discovery is probably more appropriate in advance of any mediation in those cases. So that's an issue, that is a concern. Also, the prospect of, I suppose I'm going to call it fast track mediation. So the Act provides for mediators that will conduct 3 mediations in a day. And I think that goes against the whole ethos of mediation, whereas Cathy says it's party driven. Like if you've been shoved in and out the door in that with that level of speed, I think it's a difficulty. And the whole idea behind mediation is that the mediator gets the views from both sides and then brings the views back to either side. And that takes time, and that's not something that can be rushed. So that for me is a concern, that is anticipated as part of the Act. So I think that's an issue that probably does require some further investigation.
And I might just come to you, Cathy, on one of the things that the article touches on is court-ordered mediations. And have there been many court-ordered personal injuries mediations? And does this go against the voluntary golden rule of mediation?
Yes, I think this is a really interesting area. The interaction between the court and the role of mediation. And I've observed how it operates in Ireland, and there are very interesting developments in that space at the moment in the UK. So starting with Ireland, mediation is not directed by the court in Ireland. The parties may be invited by the court to consider mediation. And the implications of declining such an invitation or declining to go to mediation in other circumstances where the court is suggesting it to the parties rests more in the space of costs. So if a party chooses for whatever reason not to engage in mediation and the dispute is ultimately litigated, the failure to take up that invitation to go to mediation in the first place can be a factor when it comes to the decisions on costs in the case. So that's the penalty, I suppose, in Ireland. But it certainly is not a situation where the court is directing the parties to involuntarily participate. And in fact, the former president of the High Court, Mr. Justice Peter Kelly, commented on this precise issue, that in his experience, and he was speaking at the time about his experience in the commercial list of the High Court, where mediation was regularly used at a much earlier stage than in respect of personal injuries litigation, that effectively there was a much less chance of the mediation being successful if it was forced upon the parties, rather than if they go to it willingly. So again, it goes back to, why is that a golden rule in the first place? It's about the mediation working. Now, in the UK, there was a case a number of years ago in the Court of Appeal, and it involved where the court would direct parties to go to mediation, and the implications of not going is that you are not entitled to then litigate your claim. So that's quite different to the implications here. And the Court of Appeal found that was contrary to the European Convention on Human Rights, because it impacted on the parties' right to a fair trial. There was a lot of controversy about that case because supporters of mediation saw it as a reluctance to embrace mediation as a method of dispute resolution. So it's back on the landscape, and there is a case pending due to be heard in October this year by the Court of Appeal to revisit that question about whether court-directed mediation is permissible. And it's interesting because the Court of Appeal have granted liberty to a number of organisations to participate in that case as amicus curiae. And so interestingly, I know the Chartered Institute of Arbitrators are involved, the Centre for Effective Dispute Resolution, CEDAR, and so on. So there's a lot of impetus, I suppose, to raise the prospect of mediation becoming directed by the courts in the UK. So it's going to be very interesting to see where that goes. For me personally, it has to be voluntary or it won't work. So I go back to former President Peter Kelly's sage advice.
In terms of what else is coming down the line, the act we mentioned, the Personal Injuries Resolution Board Act, I understand there's more provisions of that coming in as well. What impact will they have?
It was anticipated that the act would come into force in 2020. So there was a commencement order of some parts of the act on the 11th of September just gone by. Having looked at the commencement order, most of the operative parts of the act haven't yet come into being. So I suppose that's a question for government above my pay station, Andrew. Hopefully before the end of this year, but I suppose there's a huge legislative programme for the government to consider. So I anticipate it probably won't be until next year sometime.
Well, Aoife, Cathy, thank you very much for joining me. I really appreciate you taking the time today. And your article on personal injuries mediation will be available in the October issue of the Bar Review. So thanks very much for joining me.